Hi, my name's Sarah Myers. I'm an elder law attorney with the law firm of Ania, Scanlon, and Sirignano, with offices in White Plains, New York, as well as in Somers, New York. We're here today to discuss the topic of what happens if a person doesn't have the capacity to sign a power of attorney. If you've tuned into any of our prior Facebook Live programs, you've learned, and we've done a lot of programming on the importance of planning, pandemics and planning, the importance of having a will, an estate, a trust, the importance of having a power of attorney, and advance directives. However, what we haven't talked about is what happens when a person doesn't have capacity to sign a power of attorney or other advance directives. If a person doesn't have capacity to sign a will, as we talked about a couple of weeks ago on Facebook Live, we discussed that you can always do an estate administration in the surrogate's court upon a person's passing. There's a legal statute and regulations which talk about who inherits from a person's estate when they die without a will. If a person doesn't have a healthcare proxy, the document that says if I'm unable to make my medical decisions, and doesn't have that document stating who they're appointing to make medical decisions, in New York State, there's the Family Healthcare Decision Making Act, where the medical provider will look first to a spouse or children or other loved ones to make those medical decisions for you. However, there is no such statute or regulation when a person no longer has capacity to sign a power of attorney and that person had not yet signed a power of attorney. One of the problems, though, in terms of we talked about if a person doesn't have a will and it no longer has the ability to do so, you can always do an estate administration. However, the regulations in the estate administration might not be what you wish for in terms of who should inherit from your estate. And if you don't have a healthcare proxy, again, there's the Family Healthcare Decision Making Act. However, there might be a different person other than in the decision tree listed in the act that you wish to make medical decisions for you. And a power of attorney, the document that says who you wish to make financial decisions for you if you're unable to do so. Again, if you don't have a power of attorney and you don't have the capacity to do so, then we have to look to the courts and a petition under the Mental Hygiene Law, Article 81, to petition the court to seek to have a guardian appointed for that person who doesn't have capacity. Now, what is capacity? There are many definitions of capacity. There are many different ways to test capacity. In our office, we joke that similar to the Supreme Court decision about pornography, we know it when we see it, it's very similar to capacity. You know it when you see it. It's so important prior to having, when meeting with a client and trying to assess capacity, to build a relationship with that person first to determine whether or not they have the mental ability to make medical and or financial decisions for themselves. Do they understand the importance of those estate planning documents? Do they understand the nature of their being? Do they understand what their assets are, how they're titled, and how bills are paid, and how those assets are invested and used? In terms of a mental health hygiene law, Article 81 guardianship, the courts look towards the standard of, does the person have the ability to make his or her financial or medical decisions for him or herself? And Article 81 guardianship is not what's known as diagnosis driven. Just because a person has a type of dementia, a type of Parkinson's, a neurological disorder, it does not automatically preclude that person from being able to sign a power of attorney or other advance directives or other estate planning documents. When I meet with a client for the first time or a potential client with his or her parent or other loved one who may have a neurological condition, I like to first try to develop a rapport and ask questions. If I'm going into a nursing home or to a hospital or someone's home and meeting them for the first time, if I walk into the house and they're watching television, I might start by asking, what are you watching on TV? What do you like to do during the day? Do you watch the news? Do you watch the Yankees? Unfortunately, there are no Yankees playing right now. And I try to assess what that person is able to communicate back to me in terms of what they're watching, the sports, the news, to see whether or not it is timely and they have an understanding of, for example, who the president is, What's the political situation right now? What's going on in terms of sports right now or other type of arts and entertainment news? Because again, I'm a stranger to a person. I don't want to go in and start asking, personal questions to someone who doesn't know me. I also try to have that conversation last at least a half an hour to an hour, because sometimes you'll notice that a person with diminished capacity or no capacity has a set pattern, a set conversation rubric for the first 10, 15 minutes of a conversation. Hi, how are you? How's the family? How are the children? And they're able to pass and be able to be very scripted. It's usually after that 10 to 15-minute mark where the person might start becoming more repetitive or can't answer more in-depth questions rather than those initial superficial questions. I also at times might leave the room after that half hour, 45 minutes, tell them I'll be back in a little bit. And when I come back, make sure that person remembers who I am. Bring back something from that prior conversation to make sure that person has remembered the conversation and the discussion that we were having. Also, I look towards the individual and not towards his or her family members, because a lot of times when a person has diminished capacity, a child or loved one may say, remember, dear, remember you had oatmeal for breakfast this morning, right? And tries to give the person clues, which is fine. But in terms of assessing capacity, it's so important to be able to speak to the individual whose capacity is in question rather than having that family member interpret and answer for them. Because again, it's so important to make sure when determining whether or not someone has capacity that they are able to answer the questions appropriately to again in assessing. Unfortunately, there are times when a person no longer has capacity, no longer has the understanding of where he or she is, an understanding of his or her finances, doesn't recall family members anymore. And at that point in time, it's not appropriate if the person doesn't have capacity to have them sign a power of attorney, which is really like it has is a type of contract, right? The principal, the person signing, is making a contract with the agent, saying, agent, please, I'm giving you this authority to make financial decisions which are to be in my best interest. So if a person no longer has that capacity, again, we can't look towards a statute or regulation to appoint someone that way. We must go through a mental hygiene law, Article 81 guardianship, which is a Supreme Court proceeding. Most counties have within the Supreme Court a guardianship part where the proceeding is brought, where the petitioner, who could be the spouse and or child and or loved one or other family member, files a petition with the court with counsel through their counsel, basically stating my loved one, my dad, is unable to make medical and or financial decisions for himself. He suffers from Parkinson's, dementia, unfortunately had a stroke, giving the circumstances about what happened and the progression of loss of capacity, and says, unfortunately, that dad never executed a power of attorney or a healthcare proxy. There are no advance directives. So, court, we're seeking from you to appoint us the guardian to be able to handle our dads, our family members' financial and medical needs, to make those financial and medical decisions. And so often, clients will come into the office to do their estate planning and they'll say, hey, you know what? I just want to do a will. I don't want to do anything fancy. I don't need a power of attorney. I don't have to take care of these things because I'm fine. I'm healthy. I want to keep costs down. I just want a will. However, with the power of attorney, we always tell our client, look, we explain what the importance of documents are. And especially with the power of attorney, a power of attorney is not for now. That's why it's under the titling of advance directives. A power of attorney is for later, for when a person who has capacity now says, God forbid, I should no longer have capacity. I'm appointing a family member, loved one, friend, whomever, to make those financial decisions for me. So again, it's so important to have that power of attorney, because if there's no power of attorney and the person no longer has capacity, a person who has then assets in his or her name alone, or even real property titled jointly with another, no one will be able to access those assets No one has legal authority to access those assets. And again, we'd have to do a mental hygiene law, Article 81 guardianship. Many people unfortunately believe that if there's a husband and a wife or spouses, that one spouse has legal authority to access assets that are in the other spouse's name alone because they're married. Unfortunately, that's incorrect. If I have a bank account that's in my name alone, my spouse is unable to access that account unless I give him authority to do so, or unless if I lack capacity, he uses that power of attorney to access that account. So just because somebody is married, it doesn't mean that their spouse automatically has legal authority to access that person's financial affairs. So going back to the mental hygiene law, Article 81 proceeding. In the petition, again, we allege why that person needs a guardian, why that person we believe is incapacitated, and then that petition is filed with the court, the petition along with something called an order to show cause. It's filed with the court, reviewed by the court, and then the court will sign the order to show cause, giving a date to which there'll be a hearing, usually about 28 to 30 days later, and normally appointing an attorney to represent the alleged incapacitated person, the person for whom we are seeking the appointment of a guardian, to represent that person and basically stand in her shoes to make sure his rights are protected or her rights are protected. The court may also appoint an attorney known as a court evaluator to be the eyes and the ears of the court, to do an investigation for the court, to say, look, they review the petition, meet with the petitioner, the alleged incapacitated person, as well as other family members or friends, to make sure that there are no issues, there's nothing untoward going on, and to make sure the allegations in the petition are correct and accurate. That court evaluator then files a report with the court, delineating for the court his or her investigation and what his or her findings may be. That report is again filed with the court, and on the return date when we go to court to have the guardianship hearing, the attorneys can all in the judge's chambers or in the clerk's office review that report. That report in most counties is sealed by the court and cannot leave the courthouse. And then we have the guardianship hearing where the petitioner, the person bringing the proceeding, has to testify as to why mom or dad lacks capacity, why they believe there's a lack of capacity, and why they're seeking to be appointed that individual's guardian. The court will then make a decision, and a judgment is filed with the court along with something called a commission, which is the permission to act by the guardian. And that's then the commission is used for the appointed guardian to start what's called marshaling their ward's assets, to create guardianship accounts, and then start paying bills that the ward has. So that's in brief how then a person gets appointed to be someone's guardian. It's a lengthy procedure and it takes time. It involves the courts, so it's also a bit more cumbersome and expensive. But unfortunately, when a person doesn't have that capacity to sign a power of attorney, the only way then for someone to be able to legally access and handle their financial affairs is through that Article 81 mental hygiene law guardianship proceeding. A lot of times also when a person doesn't have capacity, but they have a power of attorney, but the power of attorney is either defective, it wasn't done appropriately, or was done on the wrong type of form, or if the power of attorney does not allow for gifting, does not specifically allow the agent to make gifts of the principal's assets, we also seek to bring a guardianship proceeding, requesting court permission for the guardian to make gifts of the ward's assets, normally to his or her spouse, and in certain situations to a blind or disabled child. When does that type of guardianship come about? Usually that guardianship is done in the context of Medicaid planning. For example, and this happens quite often in the elder law and estate planning arena. Unfortunately, dad had, fallen, he broke his hip, ended up in the hospital. It turns out the kids hadn't seen mom or dad as frequently as they wished, and that mom had been covering for dad and his lack of capacity. She was taking care of him at home. She was no longer then able to take care of him, or he had this fall, ended up in a nursing home, and really was going to need to stay there past the Medicare rehabilitation coverage and for long-term care. The family wants to apply for Medicaid to cover the cost of the long-term care. However, their assets in that individual's name alone, possibly a house title to his name and his wife, and we want to be able to move the assets to the spouse to enable him to be eligible for Medicaid. If there's no power of attorney, or if the power of attorney does not allow for gifting, a proceeding in Article 81 of the mental hygiene law proceeding can be brought in the state Supreme Court seeking to do Medicaid planning, requesting of the court, saying, court, either there's no power of attorney, like the prior matter, or there is a power of attorney, but the power of attorney does not allow for gifting, and we're seeking to be appointed the guardians in order to allow the guardians to do Medicaid planning and allow the guardians to transfer the ward, the Medicaid applicant's assets from his name to his spouse's name to enable him to be eligible for Medicaid. So in terms of Medicaid planning, when there is no power of attorney, or again, there's no power of attorney which allows for gifting, the guardianship proceeding can be a very valuable tool in terms of being able to move assets out of that individual's name to enable him or her to go on to Medicaid for Medicaid to cover the cost of long-term care. So again, as we've talked about these past probably 8 or 9 weeks on our weekly Facebook Live, it's so important during this period of time, but frankly, all the time, to do good and appropriate estate and if need be, Medicaid planning. And we've all discussed the importance of having a power of attorney for anyone over the age of 18 who's then considered an adult. And the reason being is if there is no power of attorney, again, there's nobody who has legal authority to access your assets if you become incapacitated. And again, capacity is actually a legal word. It's not a medical term. And it's defined as, does the person have an understanding of his or her assets? Is the person able to make financial and or medical decisions for him or herself? And again, unlike a healthcare proxy, when there's no healthcare proxy, the document that says I'm appointing someone to make my medical decisions for you, when there's no healthcare proxy, the medical providers can look towards the Family Healthcare Decision-Making Act and look towards a decision tree of individuals to make those medical decisions. When there is no power of attorney, the recourse and the redress is that Article 81 guardianship proceeding. So again, this is to really reinforce the importance of comprehensive estate planning from the advance directives through wills and trusts, especially because there are no alternatives when a person doesn't have that power of attorney. Also, when you have the power of attorney, you're designating who you wish to make those financial decisions for you. When there's no power of attorney and there's capacity that's lacking, it's up to the court to decide who the court's going to appoint as your guardian. And again, it might not be the child that you would want. You might have multiple kids, and the child who's bringing the petition is ultimately going to be appointed may not be the one you would have chosen had you had capacity and had you had the ability to make those financial decisions, to sign a power of attorney when you had the ability to do so. So again, it ultimately, shows how important it is to do that planning in advance. Um, and it's so important also if planning hasn't been done. And we're speaking to a lot of new clients now who have never done planning and they realize your pandemic brought them to the point of realizing that they probably need to do their planning. It's something that planning can control. And again, it's so important in lifetime to have those advanced directives, the power of attorney, the healthcare proxy, the living will, so then it's not up to the court to make the decision as to who should be appointed your guardian and having oversight of that guardian, and rather than be taking control and taking care of the important estate planning documents while you have the ability, while you have the capacity to do so. So sometimes people ask, well, how long does a guardianship last? Well, a guardianship for the most part will last until the person, the ward, passes. And each year, a guardian has to account to the court, file what's called an annual accounting. So the annual accountings for the year 2019 were actually just due in the court this past May. every year they're due in May, has to file an accounting with the court, which is reviewed by the court and someone called a court examiner. And you have to document how often you saw your ward, which must be at least 4 times a year, all the income that's come in, what the assets are, and all of the expenses. So the guardians, all of the guardians' acts in terms of finances and finances are all reviewed and scrutinized by both the court examiner as well as the court to make sure the guardian has not used the assets for anyone other than for the ward, and to make sure the guardian is doing his or her job appropriately. Unfortunately, there are times when a guardian misappropriates funds or does not follow the rules of the guardianship, and those actions are usually picked up on that annual accounting. However, for the most part, guardians are appointed by the court, and many times the petitioner, the family member, who really want to do right to make sure their parent or loved one is protected and their monies are used for them. Or if they had court permission to do Medicaid planning, those assets are transferred to the spouse. It is important to note in terms of Medicaid planning, the mental hygiene law Article 81 statute and the courts are very pro and for Medicaid planning in the context of a guardianship using the theory of substituted judgment. The courts will say, look, this person, especially more likely than not, would want to protect his assets and have his assets go to his spouse rather than use them to pay for the cost of his long-term care. So we, the court, are going to allow that substituted judgment and allow those transfers to happen. But again, going back to the beginning, if a person has a comprehensive health power of attorney, which appoints an agent to make financial decisions and also allows that agent to make gifts of the person's assets, it obviates, it eliminates the need to have to go to court to bring an Article 81 proceeding, because there's a comprehensive power of attorney to be used to go into effect when the individual no longer has capacity. So again, when meeting with the person who might have limited or diminished capacity, it's always very important to assess and make sure to see whether or not the person can sign advance directives and documents, or else again, more likely than not, if there's no capacity, there'll be that Article 81 proceeding. I have a question here, and I had a very difficult Article 81 proceeding, an individual who held a power of attorney proxy before he asked for replacement. The individual still refuses to return property. She also claimed the power of attorney had authority to sell property. Are the sales and alleged sales null? She was never guardian and was replaced in a timely and informed manner. That's actually a very good question. Again, if a power of attorney has been revoked, then the power of attorney, the principal, if a principal is revoking a power of attorney, that revocation has to be in writing and noticed to and mailed to the person who is the appointed agent and acting thereunder. A power of attorney also dies with the individual. So if a person has a power of attorney with an agent acting and that person has passed, that agent no longer has authority to act under the power of attorney, because again, the power of attorney dies with the principal, and the agent can no longer access or manage those financial affairs. If there is an issue in terms of the actions of an agent under a power of attorney, a Supreme Court matter can be brought against that agent, stating that perhaps the agent did not act appropriately using the power of attorney, or the agent misappropriated funds, or the agent acted inappropriately and not in accordance with the power of attorney statute, which is found in the general obligation law. If a power of attorney, the individuals refuse to return property. And again, the question posed here, you can always feel free to give us a call in the office. I think these are very specific, particular questions that I believe it'd be hard to answer comprehensively on a Facebook Live program. But also it is important, if a person is appointed an Article 81 guardian and wishes to sell real property. So for example, your ward is in a nursing home and the home is vacant. In order to be able to sell that person's real property, you have to seek court permission to do so, because you have to show the court that there's the person, your ward is not going to be returning home. The person needs to be in a nursing home for the appropriate level of care. And that also this is an appropriate arm's length transaction, that it's not a sham transaction where the guardian may be benefiting. So again, there's a significant amount of court oversight of guardians. And a lot of times when their families are fighting and there are questions on whether or not mom or dad had capacity to sign a power of attorney in the first place, or if an agent under a power of attorney is misappropriating funds, that's also a time where family members may bring a guardianship, because a guardianship supersedes a power of attorney in its authority. And if a power of attorney is not being used properly, a guardian can be appointed. But ultimately, it goes back to, if at all possible, it's so important for individuals when they have capacity, when they have that understanding, to sign their advance directives, their power of attorney, their healthcare proxy, along with their other estate planning documents, because you're planning for, God forbid, you should lose capacity in the future. You're appointing someone to make to make your financial decisions for you that are in your best interest. I hope everybody enjoyed the talk, the Facebook Live talk today on what happens when a person doesn't have capacity to sign a power of attorney. Again, my name's Sarah Myers. I'm an attorney with the law firm of Ania, Scanlon, and Sirignano, with offices in White Plains and Somers, New York. Our office number is 914-948-1500. In compliance with Governor Cuomo's New York on pause, we are all working remotely, but our phones, we do have somebody answering the phones and scheduling appointments, which we do via phone or via Zoom or any other video or telephone matter. Other questions are, my email address is s.myers@esslawfirm.com, and our website is www.esslawfirm.com. We hope to see you again next Wednesday, 2 p.m., for our weekly Facebook Live program. Thank you all for joining us, and we hope to see you next week. Bye-bye.